Honoured to have Grant Abbott from LY Legal. Grant is one of Australia's foremost authorities on self-managed super funds, estate planning, family wealth protection, and legal structuring. Over the past 30 years, Grant has built, scaled, and exited multiple ventures at an intersection of law, accounting, technology, and financial services. With a career marked by foresight and industry disruption, he, with his fellow directors, are now focused on scaling his most ambitious ventures yet: Lightyear Docs, Lightyear Training Group, Legal Back Office, and other strategic legal tech initiatives. Pioneering ventures driving next generation legal tech, AI, and family legacy preservation. So we're really honoured to have Grant today to actually, go through all about family wealth protection, how to secure your legacy for generations to come. So yeah, thanks a lot for your time, Grant.
Oh, thanks for that. So I've got a few slides here, but Paula, you're very lucky because Paula's a legend. So she just came through a few days training with me, and every time you go for a deep dive, Paula will tell you there's no end in sight. And particularly, I just want to give you a bit of a background of where we're at the moment. Protection of your assets to me is probably the most important thing. I was dealing with a builder this morning who has just come through 2 years of litigation, and his wife was almost made bankrupt. They're very lucky to get away with their house, but they had to refinance it, and it's simply just because something happened on the building, not happened on the building site, but there's a defect and so on and so forth. So it piles up, and then it's not so much the damages may well be, it's the court costs. Because if you lose a court case, you're up for probably $200,000-300,000 in legal fees, and there's the 2.5 years. Whereas some of the strategies you're going to talk to today about, wouldn't have been an issue. If he'd seen me 3 years ago, he wouldn't have had a problem. So, and we have to look at it that particularly the way the governments have, what I believe, overshot their mandates. We obviously started to see that with COVID, and that worries me particularly. And Paul will tell you, I've been talking for a long, long time about the imposition of an intergenerational transfer tax, which is a death tax, and also wealth tax, which we now have in self-managed super funds if you've got a balance above $3 million. So the government is talking about this intergenerational side, which I don't trust them anyway. So they're going to take from people who've got a lot of money and who are older and work their asses off. Sorry to use that word. And then they're going to tax them. It'll go into their coffers, but I bet you at the end of the day, it won't go down to the next generation. It'll be squandered here or squandered there or whatever. So we need to be on guard and really get our ducks in the line, because if you look as though you might even get anywhere near estate planning taxes, and the Productivity Commission have said that once you get over $500,000 in assets, then it should be taxed at 20%. In UK, it started off at 20, now it's 40. So things are going to get worse. The problem is once they introduce that, then obviously the smart people used to go and gift their assets away to the kids before they die, but they introduced a gift tax as well. So we need to be on top of that. We need to be on top of litigation. When we build a family wealth protection, it's family. It's not like grant protection or Paula protection. We're looking at protecting all the way down your bloodline. And again, it should only be for your bloodline. So for example, if Paula ends up, her partner or husband, passes away, she goes and gets another man. I can't imagine Paula's going to have another baby, but if she did, then that child should not be part of the structures that we build that really started with the congregation of Paula and husband. So I think that's fairly important. So a couple of things I'm also going to talk about. So my first love has really been, or I started I think my first love is tax, but that sort of led me into self-managed super funds. And I've written 5 books on it and been right from the start. So I've given 2,000 presentations, and anyway, I know my stuff when it comes out of self-managed. And I think that, from that perspective is that I'll give you a few strategies today for those who haven't got a self-managed. I'll talk about why it's important. For those that have, I'll talk about some of the strategies we need to look at. But essentially, it's going to be about family wealth protection, which is probably pretty customary. And I'm going to end up just talking about some various structures and strategies there for you. So this book here, Family Wealth Protection, is the first edition was sold out, unfortunately, in about 6 weeks. So I've got the second edition on my desk. I just need to go through and update that and just check all the page numbers. So that'll be up on Amazon in the next hopefully 3 weeks. Kindle will be up probably next week. So it's all about family wealth and SMSF protection for your bloodline. So litigation, we just talked about the builder, so that's a big issue. Family law, we need to protect our own assets. It's hard, if you're already together in family trust or stuff, to protect your assets from the current relationship. But certainly if you are going into a new relationship, or have been divorced, or been widowed, or more importantly for your children, you want to make sure that they're protected. A classic story I always talk about is my daughter's best friend, whose mother, her grandmother actually, gave her a $2 million apartment down in Melbourne, and then at age 25. So it was a great start, and could be champagne all round for that one if that happened to me. But then her boyfriend of 4 years up and left, got a family lawyer. She had to sell the property and give him $900,000. Whereas it could have been achieved a lot easier to keep the property in the name of her, but instead of giving the money directly to her to buy the property, it would have been better to put the money to a trust and lend that money to her at a nil interest rate. So that at the end of the day, when the family lawyers come around, you've got a $2 million property and a $2 million loan. So how much value do you have? You've got nothing. So that would have been the smarter way to go. And we want to do that. And here's the first little tip for you is that if you're giving money to your children, or you're going to give money to your children, whether it's a small amount or large amounts, the idea is to have a loan agreement in place. So you can have a chat with Paul around that. Alternatively, one of the elements is if you like anything that we're talking about, and look, there's going to be lots there, one of the things, you can come and have a complimentary meeting with me. It takes about 45 minutes. We go through all your details, and I sit down and educate you about how all of this stuff applies to your particular family. And what I'm doing is I'm looking for risks. So I'm a bit like an insurance assessor. I'm looking for all the cracks and the weaknesses. We do a lot of work with parents who've got children with mental disabilities. We do work with blended families. If you've got a blended family, you need to come and see me. It's absolutely crucial. For each state in Australia, generally most of us have been told to get wills, but more often than not, wills can be quite irrelevant, because what happens is you'll pass away and you might want to give this money to this child or this money or whatever. And you can actually have a position there that if there's an eligible person, which are children, stepchildren, they can all make a claim on the estate that they should be adequately provided for. And there's even been cases in New South Wales where normally joint assets going from one person to another, stepchildren have been able to get in and force the sale of an asset because they need to be provided for. So we've got a lot of stuff that's happening. And again, family provision laws are pretty pernicious in Australia, so we've got to be careful. Of course, we've got all the ATO, the ASIC and ACCC, who can step in at any point in time. One of the other ones is, as Paula said, she's been using some of my AI tools, and they're quite amazing. And they're only going to get better from here. They need to be structured in a certain way. You can't just go into ChatGPT and ask a question and expect the right result comes out. But we're building research databases behind, so we've got a curated brain for that. The problem about that is over time, whether it's 2 years, 3 years, 5 years, but certainly happening now, we're starting to see entry-level white-collar jobs are starting to dissipate, but it's easy to use AI for those. I think we're still probably maybe 2 or 3 years, or hopefully 5 years away from large-scale adoption of AI to take over, to essentially take over a lot of work jobs or white-collar work jobs and displace them. The problem is, I'm just going to put it to you, the thematic there is that if we lose 10 to 15% of the workforce to AI, that's going to have a really deleterious effect on housing prices, because most of those people, and we're talking about people earning between 100 to 250, 300, is that those people have large mortgages, and if suddenly there's a lot of properties on the market and the banks are, having to do mortgagee in possession, that's going to have a really bad impact on first the budget revenue, and also then obviously in properties. Now, I'm not saying it's going to happen overnight, but it's something we need. Again, I look at risks and I can see that's a risk coming down the track, which is, again, we come down and have a look at the bottom one. Wealth taxes are on the agenda. So we've actually gone through the productivity summit. I don't know why it was called a productivity summit. It should have just been called, an extra tax. So you saw them, they're talking about the spare bedroom tax, but they've got wealth taxes and intergenerational transfer taxes, which are going to be quite significant. So again, this is another risk to your family wealth, and that's going to be fairly careful. If you have a look over in England, essentially over there, if you pass away, the first $600,000 is effectively tax-free, and then after that, it's taxed at 40%. So a lot of farms end up getting sold, and money ends up in the government coffers, which isn't the right thing. So these are all the risks that we face, and so then it's a matter of building structures and strategies to effectively fix it up. The easiest way is to simply sell up everything, go and live in Thailand and have a Singaporean company. That's the easiest way of doing it, but none of us can do that because we've got family, we've got kids, we've got all that here. Excuse me. So we need to come up with some other strategies. What we want to do is we want to build our castles, and we want to have some structures around that. But at the end of the day, we want to make sure we have no net wealth in our own name. So we might have assets in our own name, but we want to build structures where our wealth is actually shifted or domiciled elsewhere. So that way, if we do that if we get sued individually, we've got this huge moat. And again, like a family provision law, remember I was talking about that with your wills. If there's nothing in your will, then how can anyone challenge it? New South Wales are a bit different rules, but people can't challenge it. So again, we want to make sure we've got a really tight castle. And it's not only for us, it's going to pass down. I mean, you can see this castle's from the 16th century. It's been around for a long time, and the structures we build should last at least 100 or plus years. So we want to make sure we make a good investment. Okay, so let's go to the first one, trusts, and we'll start talking about trust. They started talking a little bit about taxation of trust, but that's not really an issue with a lot of our strategies, because we're not looking at tax minimisation necessarily through trusts. We use self-managed super funds, which are better. So when I have a look up on the screen, you'll see it's called a discretionary trust. It's been around since the 12th century. It came about under the law of equity. So in those days, there was a common law. So there was no statutes, there was no bills, nothing there. It was just, well, this is the way that things go, that if I'm having if I'm doing some services from Paula, and I said that, Paula's going to pay me 5 shekels or 5 shillings or whatever, then at the end of the day, when I do those services, I expect that. And then if there was a fight, the common law said, well, hold on, you've entered into a contract. What happened in the 12th century is a lot of knights would go overseas and fight for the kings of the day, the King of England, and the King of England would then give them property as part of the services rendered. The problem about that is that quite often the knight wouldn't come back, as you would expect. So they would then put the property in the name of their son, or alternatively their brother or whatever. Mainly because women weren't allowed to have property in those days. We go back to the 12th century here. And then the knight would come back, if they were lucky to, after fighting, put their hand up and say, look, I want my property back. And in those days, it would be, well, no, you can't, because common law said, well, the title's in the name of your brother or your father or your son, and that's where the law of equity came, because the law of fairness was that, well, hold on, no, that person while you're overseas is really holding it in trust for you, and that's where the trust came about. So in a trust here in Australia, some of you may already have a family trust or a discretionary trust. The one you've got is probably good for tax, probably 8 out of 10 for tax, but it's probably 1 out of 10 for asset protection or family wealth protection. So you can see there's three key elements there. The most important is the beneficiaries. The beneficiaries they've got a right, not a right, but there's a potential entitlement that the trustee will distribute income or capital to them at any point in time. Generally, we distribute income each year on the 30th of June. Failure to do so is that you get taxed at 47%, or the trustee does. So we end up with a trustee. So the trustee is going to be the people who are operating the trust, the business managers, so to speak. What happens there is quite often the tax trusts that we see that are good but poor for asset protection, they actually put the names of mum and dad and the kids in there, which is extremely dangerous, because suddenly where we've got protection because we don't want people's names in there, we're suddenly putting them front and centre. And there's been a number of cases where beneficiaries who haven't been distributed to because the parents don't like them or whatever have been able to remove their parents as trustees. So it can be a bit of a disaster. So generally what we'll do there is we keep it for us is that if it's two parties and their children that come in at a later stage, it's only ever going to be for their bloodline. So they're like the king and the queen, and from down there, it's only their bloodline. So that now protects, for example, if one of them passes away, then the assets will be automatically taken up by the next one. Now, mind you, the assets aren't in their name, it's in the trustee's name. So it means that ultimately if there's litigation against them, or alternatively, they're in a family law action or they get in relationship with someone else, it's all protected inside that trust. And likewise, that then folds down to the children as well. So when the children take part of that trust, and it's not like you need a will or a self-managed super fund where you have a binding death benefit nomination or a self-managed super fund will, when someone dies, it just the trust carries on. And the way we set up trusts, they go for into perpetuity. So just as this natural progressing event, and so there's no capital gains tax, no stamp duty when it goes from one generation to another. Importantly for us is that when mum and dad die, we tend to split the trust. Again, this is really very, very new technology. If you go and ask a lawyer or a tax accountant or your accountant, apart from Paula, they'd have no idea what I'm talking about, but it's pursuant to a ATO ruling. And I've written 30 articles on this particular strategy, which I find is great for children. So you can have your 2 or 3 children sitting in there, and each of them have their own little fiefdom. So when we go back up here, we've got one child there, we've got another child there, another child there. And the good thing about it is, particularly we deal a lot, as I said, with children with mental disabilities. We can have C3, who's the child with a mental disability, could have like 40 or 50% of the trust. Because obviously they've got greater needs. Now, if you try to do that outside in a will, there's no way it's going to happen. You can't exclude anyone from a will because they'll make a family provision claim. So it's only ever going to be bloodline beneficiaries, and it's going to split on your death. So these are the modern cutting edge technologies that we're using. In terms of the real power behind the throne, so to speak, is the kings and the queens. And we've come up with the name the family protection appointor. So they're like the protector of that trust. They can remove the trustee, they can remove beneficiaries. So, for example, it's usually mum and dad are the first ones, and then it goes down to the next generation. I deal with a lot of builders, a lot of professionals, etc. They've got young kids, and so the first question I always ask is, well, who's actually going to look after the kids if you both die? And probably about 80% of people have at least got an idea of what's going to happen. 20% don't, so they need to get on top of it, because we might make, the brother or sister, whoever's going to look after the kids, the next family protection appointor, and also the director of the trustee company until the kids turn 21, 25, or whatever you really want. But obviously they'll be excluded as beneficiaries from that. So more often than not, if you're running a business and you've got shares sitting outside, then essentially what we want to do is we want to make sure that everything sits now under the Family Protection Trust. There's a number of capital gains tax exemptions that allow us to do restructuring. A more advanced strategy is that ultimately, if you've got a business, we might have our operations company, which is where there's potentially danger in if you're a builder or you're an accountant or whatever. And then we can pull out our intellectual property, our goodwill, our client base, marketing processes, business process, and we put them in a separate company because that's our crown jewels. Remember, this is like the Buckingham Palace of Trust, so it's like crown jewels. So again, that's more advanced strategy. But remember, at the end of the day, is if you see something of interest, organise with Paula and also Divya to get a meeting with me, and then we can look at your specific circumstances. I'm just telling you exactly what I do for a lot of clients. We also have clients who in startups, so we put them in an asset IP company, which they can then potentially license offshore if need be. Family testamentary trust. Again, you can start to see that technology that we like around the trust provides protection. So ordinarily, what we would do is with a will, what I ordinarily see is that, everything goes to the other partner, and if they're both dead, then it's split between the children. So the children get money or property or whatever you want to will. That's extremely dangerous because, again, go back to that story I told you about my daughter's friend. If you give or you will something, whether it's assets or cash, to one of your children, then you're exposing them to litigation and family law straight away. And I've actually seen, because I get to see so many cases a day, I've seen cases where people have married into relationships on the expectation that a parent's going to die, they'll get the money and then they can walk away. So again, there's some nasty people out there. So what we do is, again, we want to make sure everything goes into a family testamentary trust. So this is a trust, unlike the Family Protection Trust, which is created now for you. And that's what I prefer, to have something now that holds your wealth. This trust actually is created on your death out of your will, which is dangerous because to get to the testamentary trust, you need to go through any family provision claim. With farming families, we find that there's a lot of fights now where one child might have been on the farm for a long time and essentially worked the farm. And there was a case a couple of years ago in New South Wales where the son was to get 80% of the farm. The other son was to get 20%, which was a homestead on the farm. And the other son said, well, no, Dad said it was 50-50. And after 2 or 3 years, $2.5 million of legal fees, it was upheld that there should have been a 50-50 split because Dad had made the promise to the children. So here's the first thing: never make promises to your children. Also, to get it, before you get to testamentary trust, you have to pay off any ATO debts, creditors, and now wealth taxes and intergenerational transfer tax. So we might set up a trust, but oh my God, to get there, we've got to jump over all these hurdles. So again, love trusts, hate having assets in your own name or wealth in your own name, but here there's a danger. So ultimately, it's great if we can upfront get as much wealth as we can into our family protection trust. Hope that makes all sense for you at this stage. So what we can do, let me just go through. Okay, so I'll get to superannuation. I won't worry about that one. So what I do for, like, what I would have done for that builder and what I'm doing for another builder is they're potentially exposed. So what we do there is we look at the assets that they have, and let's say they've got their family home. Now, no one wants to lose their family home, and I've seen that happen too often. So what we want to do is, as the builder said, I had $2 million of equity in my family home, was a red rag to a bull. So what we want to do is keep the family home in your own name. Ideally, we could transfer it into the Family Protection Trust, along with a lot of your investment properties. The danger about that one is that when we do transfer that in, effectively, there's going to be stamp duty and maybe capital gains tax. Not so much if it's your principal place of residence, but if it's investment property. So essentially what we want to do there is we want to take the equity out of that property, and then we gift that equity over to our family protection trust. And what that does is that suddenly takes my personal balance sheet from here down to here, and at the same time, it raises the balance sheet of my family protection trust, which is where we want everything for that. Now, we can either use cash and then round robin the cash back by way of a loan. If you haven't got cash, we can use a thing called a promissory note, which is like equivalent to cash. And then what happens is we put that over, that increases the balance sheet of our family protection trust, and then we lend the money back to you if you own the asset, or if it's jointly owned to both of you. And what that does, it means the asset still stays in your name, but it's got no wealth in it. So we're right back here. We've got our castle, which is our family protection trust. We've got the house out there, which we own, but all the wealth actually is residing in here. We've got no wealth in our own name, so it doesn't make sense for anyone to, unless you want to challenge it. And it's important that when there's a loan there, it's a nil interest rate or low interest rate, but you do make payments over a period of time. But when you have this, it's going to make hard, because a litigator or liquidator or family lawyer is not going to go and chase something if there's nothing there, because it's all being hidden behind, not hidden, but it's actually put inside a trust. So that's a protective mechanism. I've done a video on that which explains, it goes for about 20-25 minutes. So make sure you have a good look at that, or have a chat with Paula. So Paula can do a strategy report for you. But out of the session, if you want to have a meeting with me, come together. Paula will give a really good background. I need to know all about your family. Are there any mental disabilities? Are you a blended family? What do you want to happen with the children, so on and so forth. And then we'll go through, and then you get a strategy report from us. And if there's work need to be done, or you want to be done, then essentially we give you a fixed price quote on everything. So it's a fairly simple process, but absolutely crucial, particularly now with the potential introduction of wealth and intergenerational transfer taxes, which I always find funny, because when you have a look at look, I'm not saying anything, but, well, I'm saying something, but in the last 2 or 3 years, we've had over like 2 million new migrants into Australia, which are primarily people under 30. So we're now taking for the baby boomers, and the older people have built their wealth, and we're trying to spread it amongst people who've only just come into the country. It just doesn't make sense to me. Anyway, I'm not a politician, and thank goodness. So we've got our testamentary trust. Let's go on. If there's any questions, just put them up in the chat, or alternatively, put them. I see Kyle Milosh. If you got them, or put them up in the Q&A, I'm happy to do that. So we've learned about the testamentary trust, but to get there, it's like, we've got a lot of stuff to get through. But if it's just a basic case, and then there's no family provision claims or dramas, then absolutely we'll put a testamentary trust in there for you. And the reason we do that, because if you've got a family property, then potentially there's capital gains tax, or a stamp duty if we transfer it over the family protection trust. So we may end up setting it up in the testamentary trust. Or one of my new strategies, of which I only just started 2 weeks ago, is to actually have the family protection trust as a beneficiary of the estate, which is a good one. Now, the self-managed super fund, if we go down here, let me just give you a bit of a story on this one. Okay, we've got a couple of good questions with that one for Kyle. That's a good one here. Let me just go through that one. Kyle, absolutely. So Kyle's asking, how can you transfer assets into a trust, and does this trigger CGT? Absolutely, because if I took this property, my family home, and this is what happened with this builder, because he was so freaked out about liquidation, he took his family home and he put it into a family protection trust. Now, the problem about that is it was his principal place of residence exemption, the principal place of residence. So there's a capital gains tax exemption. So I can transfer that into my family protection trust. So there's no capital gains tax. But there's stamp duty, and this was in Queensland, so it's 6%, and this was a $4 million home, so it's $240,000. Then it's sitting in the trust, so it's okay, it's protected. But because it's owned by the trust and not an individual, you have to pay land tax. Plus, if the trust ultimately sells, there's no capital gains tax exemption going down the track. So what we do, Kyle, is we keep the asset in our own name, but what we're doing is we work out if the asset is worth, let's say the asset's worth $2 million, there's $1 million borrowing to NAB, and there's $1 million of equity. Then what we do is we take that $1 million and we use a gift, a deed of gift, and we transfer that deed of gift over to the Family Protection Trust. Now, if you haven't got cash, then what we do is a promissory note. So the promissory note says that Kyle, who is the owner of the house, the legal owner of the house, is transferring or gifting $1 million over to the Family Protection Trust. So that now means at any point in time, the trustee of the Family Protection Trust, which is going to be you, Kyle, will say, look, I can call on that loan of $1 million at any time. You have to pay me back straight away. Now, that's good. The only problem about it is that a promissory note is a short term. It's almost like a check. So it's nice to have, but hasn't really got some gravitas, some steroid or power. So what we do is we cancel the promissory note and then we issue a loan instead. So suddenly, Kyle, you've got a 30-year loan there. Again, we don't need to pay much interest, although if you've got cash, you're best off always paying off the loan, putting it over here if you need it, then you just re-borrow that money. Now, what happens there is that because we've got a loan agreement, that enables us to put a mortgage on. So under property law, depending on the state you're in, it enables us to put a mortgage on that, which means we're always going to be the top secured creditor. Now, if the bank already owes money, or you already owe money to the bank is going to be what we call the first mortgagee, and the second mortgagee will be your Family Protection Trust. But at the end, we want to get ourselves down to nil. So you can see there's no CGT or stamp duty. But, well, it's very clever. In fact, Kyle, this has been around for maybe 20 or 30 years, even more so. Some people don't even trust Australia. So they do this methodology, and I learned about it from over in the US. They do it using offshore trusts. So they actually switch it. They don't trust the US, and I don't blame them. They use offshore trusts. So it is clever in doing that. But again, obviously, it's very strategic. Now, what I want to do is I'm just going to give you a bit of a, for 5 or 10 minutes, I'm going to give you a bit of a discussion on self-managed super funds, because that's my first love, as I said. With a self-managed super fund, if you haven't set one up, or if you set one up, essentially what I see, because I get to see a lot of people, and they're now everyone's starting to realise, particularly in my generation, the baby boomers, and to a lesser extent, people who make quite a bit of money, who might be under that age, are now starting to think, oh, I've got all this wealth, but I now start to see that the government is now, and other people are now starting to attack me because, I've got this wealth. And so protection is paramount, because it's it's not easy to build wealth. It's very easy to lose it. And once you do it, it's not a pleasant situation. So essentially what we want to do is make sure we protect it. The same thing is we want to make sure we protect our health and our mental health, and also our physical health. So what's been the traditional strategy in the past, and I see, unfortunately, a lot of people coming to me, for example, Kyle, that might have 3 or 4 investment properties, and they've followed the old Robert Kiyosaki. And look, I've been on stage with Robert before, and his big thing is to, build up a nest of properties, and essentially, once you do that, you've got the rental income, and then you can retire. So that sounds great. So I'd see a lot of people have had properties and built up a portfolio over 5, 10, 15, 20, 25, even 30 years. So they're living off their rental income, which is fine. Most of the mortgages are paid off by then. So they're getting the rental income, but all they've done is it's a passive salary. So that money's coming through, they're paying tax on it. And they'll be paying tax on it until they die. In fact, they pay tax on it even after they die, because the executor of their estate pays tax on it. Problem about that is that they've got that capital gain from when they bought is now accruing. Now there's a 50% discount on that capital gain, but I can tell you, I'm sure Paul will tell you as well, that discount, it's not going to be 50%. They've already talked about dropping it down to 25, and who knows if it won't go down a little bit further. So you got this latent unearned capital gain, which is sitting on that property that someone's going to have to pay capital gains tax. Worse still, if you have a look at it, if they use in self-managed super funds, if your balance is above $3 million, then unearned capital gains, so unrealized capital gains, and this is stupid, unrealized capital gains are actually included as part of your income and taxed at 15%. That only that portion that relates to over $3 million. But the worst thing is then if you sell the assets, you're also subject to capital gains tax. So the system is crazy. But that's one of the first indications of a wealth tax in Australia. At some point in time, they can simply lob that in and put it over to people who've got their own assets. So those people who've got all those properties themselves are in a bit of strife. Now, when we bought those properties over time, we've always had to save after-tax money and, get money to build a deposit, so on and so forth. Whereas in a self-managed superannuation fund, we can put in, $30,000 from our business each year or $30,000 and then get a tax deduction for it. So that means it's a reduction of my PAYG or my business income, family trust income. It doesn't matter, it's somewhere along the line. So if you've got partners, then that's effectively $60,000 can go into self-managed super fund. If you've got $250,000 or $300,000 in a retail or industry fund, you can now put that into a self-managed super fund. You can do the same thing, negatively gear inside a self-managed super fund. Negative gearing is you go and buy a property, you can get up to 80% loan to value ratio. So if I've got $300,000, I could go and borrow $700,000 easily and suddenly get $1 million portfolio, which I'm going to pay off over a period of time. So it seems to be, it's a bit of a no-brainer. Now, when we do that, we get rental income, and from the rental income, we're going to have interest deductions, capital appreciation and depreciation, same as out here, outside of super. And that means we might end up with a tax loss. But the tax loss, because these $30,000 deductible contributions effectively are just like rent income or interest income or assessable income of the fund, we can offset those tax losses against these salary and wages we've put in there. So it means ordinarily we're in a retail fund where we get this contributions tax of 15%. Inside a fund, if you're negatively gearing, you're never going to pay 15% contributions tax. It might be 10 or 12. The big kicker, though, is once you turn 60 or at latest 65, if Paula's still working, you're going to tap her on the shoulder and say, well, I want to start my own private pension. And once you do that, the good thing about that under the current laws, and who knows what's going to happen down the track, but essentially there is that suddenly rental income is tax-free. Now, once you're over 60, if you take any money out, whether it's pension income or lump sums, it's tax-free to you anyway. So suddenly you're in a better position because people with the same property outside paying tax at PAYG on that rental income. Inside, same property, same property, same rental income, but no tax. Likewise, if I move it over and sell the property after a year, there's no capital gains tax. So suddenly that just dissipates over time. The same thing if I leave that property to my children, if I did that through the will, the kids would have to pick up the capital gains tax bill. If I did that through super, no capital gains tax. So it's 5 times better building in self-managed super funds. But we don't necessarily want to put all our eggs in one basket. So we want to use some SMSF and family protection trust. If we want to do it individually, we can do that. If we want to negatively gear individually, then the strategy is to use this. We put cash into our family protection trust, the bank will lend to us, and then we lend back to ourselves. So suddenly we've got 100% gearing, which is fantastic because that means that we're going to maximize our tax deductible interest income, the income will go into our family protection trust, which can then be split with our wife or others there if we've got children over 18. So it's very, very tax efficient. So, and if we've got a SMSF, then we need to do what we call an SMSF will. And quite often we'll end up doing this. We take the benefits out of your SMSF when one dies and we put it into a family protection trust. But there's around about 4 or 5 different options there. So just to go through a bit of summary, we talked about the problems of our assets. We want to get to this one, remember. We've talked about a family protection trust that essentially everyone is hidden. It only relates to the main two people or the main person in there and then their bloodline. So it's a very narrow focus. But on death, it gets split. There's no capital gains tax. We don't have to worry about challenges. It all carries on down the track, only for bloodline. For the advanced business people, we want to get our operations company underneath there. Depending on the size, we can actually do that capital gains tax free. I'd also say maybe separate your good value, your crown jewels out of your operations company into your IP company and then put that under the family protection trust. And then this licenses it back to the operations company. So we pull out all the cash out of here. So if someone sues it, we've got nothing there. Everything's protected. Family testamentary trust, fantastic. We may want to put that. If you come and get a will, we're going to put that into your will. It's very easy, but remember to get to the testamentary trust, if we've got any of these issues that we're worried about, then what we're going to do is we're going to go down this track. We're going to do a gift and loan back to keep our estate, keep our personal balance sheet clean, which is important. Finally, we talked about self-managed super funds, SMSF. So I've got clients who have done extremely well. Some Australian rules footballers have done extremely, extremely well by investing in cryptocurrency. I haven't, but there's some people who've done extremely well in crypto, options trading, shares trading, foreign exchange trading, but properties. Certainly in the long term, I see that people who've got property investments inside a self-managed super fund are the best. A couple other ones. We've got a crypto protection trust, special disability trust. If you've got a child who's on a special disability pension, you can put assets into a special disability trust. Normally they're means tested, but if we put a home in there or a family home, it's exempt. Likewise, there's no capital gains tax on transfer of assets in here. So we've got assets in a family protection trust. We can transfer it in. No stamp duty, no capital gains tax. And then we can have $830,000 of assets in there, assets test exempt. So special disability trusts are great. And the final one, if anyone's got child support and you're running a business, then I could show you how to get a tax deduction for child support instead of after-tax money. So that's sort of a bit of a whirlwind around it. And there, I've got about 40 strategies that I can apply at any point in time. The main thing for it is that, again, if you want to come to have an appointment with me, just book it with Paula. Paula has been through all my training, so she can answer most of your questions. But if you're looking at a full-scale restructure and you're worried about wealth tax, worried about, you're in a blended family and stepchildren, your kids are going to miss out because of the stepchildren. That's how I got involved in the first place. My dad was aghast, and if you read my book, Family Wealth Protection, Dad was shocked that because I was in a marriage at that time and had stepchildren, if I passed away, that my assets would go to my wife at the time, and then if she passed away, go down to her children. And like I had no bloodline protection, and so that's what started me moving away from self-managed into this family wealth protection space. But we really need to make sure we're on top of that one. Okay, so if you'd like to, so it's lovely chatting with Paula. She's a super smart accountant. So, but I think just have a chat with Paula, make an appointment, and we'll get together 45 minutes. I just need to know what structures you are. If you've got any risk, you can ask me as many questions as you want. This is being recorded, so we'll send it to Paula and she can send it out to you as well with a couple other videos. So the main thing is don't put your head in the sand, educate yourself. Read my book. The second edition's coming out very shortly. So deep dive into that one so that when you're coming and meeting me, we've got some really good repartee going around the strategies. Because the more you know, it's like going down a rabbit hole. Because if you go to most, I tell you, here's an interesting one. Most estate planning lawyers are dopes, absolute dopey. I'm dealing with one client and her mum left her, 3 quite sizable apartments in New South Wales. She was in a relationship down in Victoria. with a partner who had stepchildren. So that's a worry because remember, we said stepchildren can make claims on the estate. They had a daughter, so they had a bloodline daughter between the two of them. She wanted to make sure the bloodline daughter was looked after, not the stepchildren. And then the mum in the will had transferred or said gifted the 3 apartments directly to her. And remember, I talked about my daughters. So as it goes to her, it's like, oh my God, if he ups and leaves her, then suddenly she's going to have to sell it and she's going to lose half her assets. And so it'll go down outside the bloodline. And so I rang the lawyer and I said, well, why did you do this? And he said, well, her mother never asked for it. It's like, well, how dopey are you? Doesn't matter whether they asked for it. You should be offering full protection. So we've had to go and do some other strategies for it. But again, you just got to be extremely careful on that one. That's lovely. Sorry, Paula, you know what I mean.
No
Have a
worries.
chat.
No worries. Thanks so much for your time, Gran. I hope, everyone got some value out of that. And yeah, really, I encourage you take Gran up on his offer. He's a wealth of knowledge and he's just incredible and really passionate about, protecting people's wealth. And, as he sort of, touched on, you can see that where the government is going. And, we want to actually,
That's a big thing. People should
we
have
want everything that
absolutely no wealth.
we work for to go to our children, to our bloodline rather than the government.
Well, the
So
worst thing about it is they say, well, we want to look after the intergenerational. It's like, well, that's what we're doing anyway through our
that's
estate
exactly
planning.
right.
But what they want to do is they don't want to do that. They want to just take the tax,
Yeah,
and it's
yeah,
just all
correct.
bullshit about intergenerational because
Yeah,
it's like road taxes. I mean, road taxes we're taking road taxes or petrol taxes to make sure it's like this EV tax because you can't take petrol tax. We'll take it to look after the roads. None of it goes back on the
none
roads.
of it goes to the roads.
I
No.
know. Okay, cool. Okay, well, thanks for that. And we'll get this
Awesome.
recording and send it out to you.
Great. So yeah, everyone, you'll receive a copy of the recording in the next couple of days.
Okay. See you.
Awesome.
Have a good
Thank you.
night.
Have a good
Bye.
night. Bye.